Call to order the Shelburne Ethics Committee hearing in the matter of Pierce v. Pauza, case number 208-1211-001. We have before us a complaint filed by Dean Pierce, our town planner, and the respondent is Jeffrey Pauza, the current chair of the Development Review Board. I'll begin by administering the oath to the parties. Please stand. Under the pain and penalties of perjury, do you solemnly swear or affirm that the evidence you give in the cause under consideration shall be the truth and nothing but the truth?
I do.
Thank you. I'll introduce myself. I'm Lee Suskin. I'm the chair of the Shelburne Ethics Committee. I'll let the other members introduce themselves.
Tom Little. Pete Gadju.
Bill Deming.
Gwen Webster.
Mike Ashew.
And our clerk, Diana Vachon. We have a full complement tonight. We have 5 members and 1 alternate. Pete Gadju is the alternate, so Pete will participate in the hearing, but he will not be participating in any decision-making. Do any of the committee members have any conflicts of interest or ex parte communications or public displays of prejudgment of the merits on this matter that they wish to disclose? Mr. Deming?
I do not.
Mr. Gadju?
No, sir.
No.
And I will disclose that on the day that the complaint was filed, I had a communication with the complainant to ask if he was sure he wanted to file the complaint on that day or whether he wanted to wait a day to see if the select board would amend the ordinance, which they were planning to do that night. I had not read the complaint at the time we spoke, and we did not discuss the complaint. But it was a communication with one of the parties that I feel I must disclose. I don't think it has any impact on my ability to be fair in this decision, and I will proceed. Okay. The posted agenda that you have in front of you assumed that we would have a full evidentiary hearing tonight. Based on documents we've received from Mr. Pauza, and from Mr. Pierce, which I'm about to summarize, it appears we may not need to conduct a full testimonial hearing tonight. To familiarize everyone in the room with the issues at hand, I'm going to take some time to summarize where we are and how we're going to proceed tonight. Here's a summary of the documents that we've received. On December 11th, 2018, Dean Pierce filed a complaint and affidavit pursuant to the 2015 ordinance. In effect, the complaint alleges that Mr. Pauza participated in the DRB's March 2nd, 2016 hearing on Shelburne Green, at which he stated that he supports extending the hours of operation of the cafe. Mr. Pauza subsequently participated in a September 5th, 2018 hearing on the same issues this is according to the complaint, without first disclosing any conflict of interest or disclosing his statement prejudging the merits of the application or stating why he could act fairly and objectively despite his prior statement. In his complaint, Mr. Pierce requested that the Ethics Committee determine that Mr. Pauza violated the ordinance by making public statements prejudging the matters of a pending application and failing to disclose his statement or recuse himself at the September 5th hearing. Mr. Pierce requests the committee to require Mr. Pauza to recuse himself from any quasi-judicial proceeding regarding Shelburne Green. On December 18th, the Ethics Committee found probable cause that Mr. Pauza violated the ordinance and notified Mr. Pauza and Mr. Pierce. On December 19th, Mr. Pauza notified the DRB and the Ethics Committee he would recuse himself from the December 19th session of the Shelburne Green application. He did recuse himself from the session. On January 2nd, Mr. Pierce provided the committee and then Mr. Pauza with links to video recordings of select board meetings related to the role of the DRB and to video recordings of August and September DRB hearings and that March hearing containing comments made by Mr. Pauza. On January 7th, Mr. Pauza filed a response to the complaint in which he agreed to recuse himself from all current and future Shelburne Green applications, stating, integrity and public trust in the DRB is of utmost consideration. Mr. Pauza did not check the box in his response as to whether he admits that his failure to disclose its March 2nd, 2016 statement at the September 5th hearing or to recuse from that hearing constitutes a violation of the ordinance. Both Mr. Pierce in his complaint and Mr. Pauza in his response request the Ethics Committee to provide guidance and training to DRB members. In that Mr. Pauza has recused himself from all Shelburne Green proceedings as requested by the complaint, it may be that Mr. Pauza will tonight admit that he violated the ordinance. If so, we will not need to conduct a full testimonial hearing as authorized by the rules. So accordingly, here's how I'm going to proceed. First, I'm going to ask the complainant, Mr. Pierce, to comment, elaborate upon, or correct my summary. And I'll give you about 10 minutes or so to do that.
10 minutes will not be required.
Okay. Well, then let me keep going. Then I'm going to ask Mr. Pauza to comment, elaborate upon, and or correct my summary, and to state whether he admits that his March 2nd statement was a prejudge of the merits, and he failed, whether his failure to disclose or recuse himself constitutes a violation of the ordinance. I'll then ask the Ethics Committee members if they have any questions or make any comments. And I will then ask the Ethics Committee to decide whether we need to conduct a full hearing and ask the parties to present testimony. If so, we're going to go into a full hearing. If no, then we'll begin hopefully a short deliberative session, issue a written decision based on documents submitted and comments by the parties tonight. And then when we return, we will discuss how to respond to the parties' requests for guidance from the Ethics Committee to the DRB. Okay. Any questions about how we're going to proceed? Okay. Mr. Pierce.
In your initial comments, you referred to me as the town planner. I need to make clear that I filed the complaint as a resident and as a professional planner, but not in my employ.
Thank you.
Secondly, I was going to be asking a preliminary question that you seem to have anticipated, and the written statement that I had anticipating that question was that my reading of the public official's statement is that he does not dispute that he formed an opinion regarding a zoning request prior to the hearing where the zoning request was to be decided and made no disclosure. If the Ethics Committee concurs with that characterization, that he's not disputing that he had formed an opinion, that I was going to ask whether or not the Ethics Committee already had what it needs to decide the complaint. The only other comment that I would have pertaining to the summary of the videotapes is that I can suggest specific time points on the tape, but it seems like it's been reviewed, and that may not be necessary.
I think in the material that you submitted to the committee and to the respondent, you did have some time parts on there, and I think some or all of us have reviewed some or all of those video recordings. If we have a hearing or at any time you wish to play some of those video recordings, we're set up so that you could do that. Okay, Mr. Pausa.
Hi, so you have my statements. I don't know if I violated an ethics rule. I definitely said what I said, and I stand behind what I say, and I justified why I was saying it. So it was not just a whim comment. We were in session. We had an applicant in front of us providing information. They were talking about a change in hours. They didn't want to present that. I viewed that as it met the Stowe criteria of something unforeseen at the time the application was permitted, and I said I would support that, and I stand behind that. I don't know if that violates the rules, though, so that's the part I need clarification on. And so I'm going to play two parts. I'm going to play my part as a DRB member at that time with that statement. Then the second part is I'm going to play the part of the DRB chair, where we need clarification on what can be discussed in open hearing, open to the public, where statements might be misconstrued or not misconstrued, that a particular DRB member has an opinion on something. And then someone in the public can take that and file an ethics complaint that that person can't participate in future applications and either related to the application discussed at the time or some other application that might have similar subject matter. So that piece, I'm going to be playing the role of DRB chair. Okay. So let me go back to me, Jeff Pausa, as DRB member at the time I made those statements. I stand behind them. I don't question them. I don't challenge that at all. But what I think I need to understand is, okay, did that violate? And if it did, well, I'm not going to admit guilt because I don't understand it. Okay? Does that make sense?
I understand your question.
Okay.
What I'm hearing is, at this point, I mean, just one comment is, we are not here to provide guidance tonight. Maybe under the new ordinance, which is now in effect, but this hearing is being conducted under the old ordinance, because that's what was in place at the time the complaint was filed. Under the new ordinance, we might be able to have one or two members provide that sort of guidance. The purpose of tonight's hearing is to hold a hearing to determine whether what you did is a violation. So just to answer your question, from my standpoint, and then we'll get other committee members' comments, if you don't know whether it was a violation, we'll conduct a hearing, and when we issue our decision, you will find out. If so we can only curtail this hearing if the parties in effect stipulate that there was a violation, and then we decide where to go from there.
Okay. So hypothetically, if there was a violation, what would happen? I've already recused myself from the application.
The ordinance provides potential sanctions.
Such as?
So under the old ordinance, the vice chair has it in front of him. You want to just speak?
Chapter 5 of the applicable ordinance says that in addition to any other remedies, provided by law, the Ethics Committee may place a copy of its written decision in a public file maintained by the town clerk and may publicly censure a public official who violates the ordinance and may recommend that the select board remove the public official from office for cause. Never had to go there yet, but that's in the ordinance, and something
Right,
similar
those
is in
are all
the,
possible sanctions. In no
Okay.
way is that a heads up that any of that is likely.
Okay.
So there's more than just recusal to answer your question. Well, I'd like, I want to make sure all the committee members, so are you done with do you have anything again, correct, elaborate, or
No,
anything
I
in
think-
it on what I said, or do you, so at this point, you're not admitting a violation?
I'm not, I don't know. I don't know.
Okay. I'd like all the committee members to ask some questions, and then I'll call on the two of you again. Mr. Asher?
I did have a question about Mr. Paz's response to the complaint. At the very end, if it's okay with the chair, at the very end, you wrote background, as a matter of operations, the DRB members, while in session, may present opinions, substantiated or not, on a particular subject. This may be interpreted as bias when dealing with the future applications of a similar matter. I wasn't quite sure what you meant by that, and I was just wondering if you could explain that a little.
Sure, I can. So when the DRB is in session, if there's an applicant's in front of us with an application, I'll just pick a hypothetical example. Road width. The applicant wants roads that are 25 feet wide, and we debate that within the DRB because it's a hot topic. And maybe the road should be wider because the fire department can get their trucks down. But maybe the road should be narrower because narrow roads indicate more safety in a neighborhood. So someone will say, well, I support the narrower roads because they're safer. Someone says, I support the wider roads because it's good for our town. Okay, opinions are now rendered in public forum, heard by the public. So now if someone else, another developer is there and they're thinking about a development, well, of course they're going to want to have, well, let me say, they might want to have narrower roads because it's more cost effective. So what they can do is they can say, that particular DRB member stated in public forum that he's for wide roads and he supports wide roads for his fire department. So he's prejudiced. So now that applicant, or that potential person, a person in the audience could say, I don't want him to hear my application.
And just to follow up, it's your belief that this is kind of the situation that you found yourself in under the complaint?
This is,
Mr.
me
Peters?
as, okay, so acting in DRB chair, we find ourselves in this situation quite frequently where we have, I'll call it active constructive dialogue back and forth among members talking about specific items. Like what's the temperature of the board? And we'll talk about it in public forum. Now, we also recognize that there may be some topics that are too controversial, and we won't do that in public forum. We'll deliberate those in private. But it's those public forum discussions, which is when I offered my opinion back in 2016, that could be used against a DRB member for future applications. Big concern, because what that does is that says the DRB, wow, we're going to be quiet because we don't want to get censured from future applications. And I don't think that serves the public interest. I think it's important for the public to know kind of where the board sits on things.
Thanks.
I have a question about the bylaws that were in effect at that point in time. Did they restrict the hours, or, because it doesn't say whether you were limited, or by the original application, did the original application limit the hours because it was a PUD, or because the zoning bylaws mandated that?
I'm going to go off of recollection. Dean, please correct me because you're the town zoning officer, that hours were identified that they had to operate. So there was predefined hours when
In the
cafe
bylaws?
No, in the particular application.
Okay.
Is that your understanding, Dean?
There is a condition in effect regarding the property that restricts the hours. The request had to
For
do
the entire property.
for the project. There was a restriction on the on the hours that a future food service use taking place on the property could operate. Having responded to that, I would object, or I guess I would ask that the committee keep its focus on the essence, which is not what the regs say. It's not a question of what the regs say regarding hours. It's a question of prejudgment.
Let me just,
But I was just curious to know if there had been because sometimes in the regulations, there are more finite,
So the short answer is, again, as Mr.
Right.
Paz said, that it's not a feature of the regulations
Gotcha.
that the hours are limited. However, a previous DRB, in saying yes to the project, said,
Conditioned
oh,
it.
if there is going to be a food service use, those hours must be restricted, and there are other aspects of the use that would need to be constricted.
correct, so that was the condition of the original permit.
I'd like, I request that the committee limit its comments and questions now, not to help us to decide whether we are going to begin a testimonial
Well, I was
hearing.
just trying to find out if he might have been limited by what the regulations said,
Oh, okay,
because
Now,
that could make a
I'm
difference.
sorry, I missed that. So that's going to be because at some point, we're going to have to decide whether to go to a full testimonial hearing or not, and that's coming up pretty soon. So I do want as many questions and comments of the parties that may help us to get there. Mr. Little?
No, nothing for me.
I have nothing.
Mr. Deming?
I guess I have a question for Dean, and I don't know whether it's out of line or not. Are you satisfied that he recused himself?
You anticipated my comment that I was going to make, which is I was going to draw the committee's attention to the fact that in filing my complaint, speaking of tick boxes, I did not tick a box asking for censure.
Right.
I specified the remedies that I felt were called for.
Right, so in the complaint, you requested recusal. From the hearing coming up that night and from all future Shelburne Green proposals. Mr. Pauza has recused himself from the December 19th hearing and and all future hearings. So in terms of, I don't know whether the committee has authority to, the committee may have authority to issue sanctions not requested by the complainant after hearing testimony. So I don't know that necessarily means that that's off the table. Do you have any thoughts on that?
I think the remedy's up to the committee after hearing all the evidence.
Right. So that doesn't necessarily preclude going to a hearing. You also requested that that Mr. Pauza be found in violation of the ordinance, and that has not been resolved yet. Any other questions from the committee? Any other comments from Mr. Pierce? Any other comments from Mr. Pauza?
Not at this time.
Okay, so now the committee, we've got to have to decide, based on what we've heard, do we proceed to a full testimonial hearing?
Well,
Is there anything else we can do?
I don't know that we need to.
Well, so the comments were from Mr., can I repeat yours? From Mr. Little, there's nothing, says nothing else we can do. From Ms. Webster, I don't know that we need to. Any other comments from the committee?
I think he's made he's recused himself, he's met the requirement, or the main part of the complaint, and I think it's all done.
It seems to me that we have a complaint in front of us requesting that Mr. Paz be found in violation. Mr. Pierce could withdraw that aspect of his complaint. That would change things. But as long as that stands, I don't see how we can fail to go forward. Do you have any thoughts on withdrawing your request?
Yes, I do have thoughts on that. The central question before you, let me stop for a second. Conducting a full hearing is prerequisite to issuing a decision or not?
I don't see how we could make a decision unless, okay, so let me just think back. If Mr. Pazza agrees to the facts, and as stated by Mr. Pierce and as I articulated earlier, then in effect, we have stipulated facts. We could probably go into deliberative session to decide whether, based on those facts, there's a violation, in which case we probably would not need a testimonial hearing. What do you think?
Yeah, I don't think that's where we are.
Well, let's say let me just see, do you stipulate to all the facts that are in the complaint?
As to what I said, absolutely, I do. I said that, and I stand behind it.
In the complaint, do you stipulate to all the facts in Mr. Pierce's complaint?
I'll have to go through it word by word, line by line, and I
Okay.
have not done that.
Okay,
I've scanned it, I read it twice. But I don't challenge what I said. I don't know if if I
well,
explained why I said it, but
I'm just trying to get to the point do we go to a hearing or not?
Okay.
So, comment from the public? Right, wait. I don't know if we can.
We're gonna hear it, whether we like it or not.
Right. Are you, no one has called, we're not in a hearing, don't have witnesses now, we can't take comments, sorry. So, we don't have stipulated facts. We have to take evidence to determine the facts. I don't see any way out. So I move that we initiate an evidentiary hearing. Yes.
Question. You were asking Mr. Pierce whether or not he wanted to continue with,
I was asking if he wanted to withdraw his.
yeah, correct. I don't think he ever answered that, did he?
What
I
I
didn't hear it.
heard was he decided he's still requesting that we find you in violation of the ordinance. Is that correct?
Yes.
Okay. So motion on the floor, is there a second?
You don't need a motion.
Hmm?
You don't need a motion.
I don't need a motion?
We noticed this for a hearing. We hold a hearing,
So we hold a hearing unless there's a motion not to.
I guess, yeah.
Okay. So we're about to, okay, is there any objection from the committee to proceeding to hearing?
I do too.
You object and you object. We have two objections. Well, I don't think we could not, the only way not to proceed is if someone makes a motion and outvotes the chair and vice chair.
how many architects are on the DRB board, but I assume there's more than two, or maybe certainly more than one. And if in their knowledge, 25-foot roads are the thing, they'll say that every time. Now, in this particular case, it was a little bit narrower. It was hours of operation, and but I think he's got a point. You
Well,
can't kill the DRB.
Well, these are matters that will come up during the hearing and during deliberations. It's just a question of whether we go to a hearing at this point.
Well, my reason for objection is that I feel in two ways. Number one way is that he's recused himself, as we all know, through the letters we received on January 7th of this year. The other thing is education process of the ethics ordinance, whether it be the old one or the new one. The CBCs of the town, we need to get them educated in how the rules work and how the rules go. And I think that's where all this dilemma is, and that's why I'm objecting to have a hearing.
Have you made a motion?
You can't vote.
You can. Bill, have you made a motion?
No, I have not.
Has anyone making a motion that we not proceed to hearing? Without a motion, we will proceed
Without a motion, we'll proceed.
to hearing.
Let's have a hearing.
Okay. So, we will now begin a testamentary hearing, and the prior agenda lays out the rules of procedure that we adopted in the past that we will follow tonight. I've already administered the oath. It still applies. I'm requesting each witness to provide his or her contact information, which I think we already have. I'll ask each of you to have any questions about how the hearing will proceed. First, the complainant.
Just collecting my thoughts here.
Okay.
I have no questions. And if you're asking
Okay.
for,
Microphone?
sorry.
Just have your questions on how we're going to proceed.
No, I have no
Okay,
questions.
Mr. Paws, any questions, how we're going to proceed? Okay, so then, I've already asked committee members to disclose any conflicts of interest, and we still don't have any, as far as I know. We're going to ask the complainant to present his testimony. You can call witnesses. The respondent will have an opportunity to cross-examine Mr. Mr. Pierce. Committee members can ask questions of Mr. Pierce, then Mr. Pausa will have an opportunity to present his testimony, be cross-examined and be questioned. Then final comments from the complainant, from the respondent, and then we go into deliberative session. Any questions? Not from the audience. We're in a hearing. Mr. Pierce.
I'm not sure how the committee views testimony as compared to argument or opening statements, but I intend for the following to be considered in the vein of opening statements, if I may do that.
Yes, assuming that it'll be followed up by testimony that relates to your opening statement. Yes,
I believe that will be the case,
Okay.
and if not, you can strike.
okay with you?
I believe the public interest is best served when members of quasi-judicial bodies approach every decision with an open mind and treat every party consistently and equally, favoring none and disfavoring none. The central question before you tonight concerns prejudgment, what it is, and whether it has any place in quasi-judicial proceedings conducted by the Development Review Board. The sum total of the testimony that I would like to have incorporated into the record for the proceeding tonight is already been provided to you. I've got nothing to add to what has already been submitted, and I would be willing to answer any questions.
You have an opportunity here in presenting your case to highlight aspects of what you've already submitted to us, because among other things, not everyone on the committee necessarily has viewed every inch of every minute of every video that you submitted. So you have that opportunity if you would like to.
I'm not sure that it's necessary. My understanding is that the board members reviewed the videos that were cited in the original complaint. As it relates to the videos that are cited in the follow-up document, I would essentially suggest that you focus in the first video for April 2nd of 2016 at around 15 minutes and 57 seconds. You summarized that as the videotape from a select board meeting relating to the appointment of a DRB member. For the videotape for November 28th of 2017 concerning the same subject, I would draw your attention to the 37-minute 10-second mark. Concerning the meeting on August 15th of 2018, I would suggest that, I would suggest that you focus starting at 1 hour, 13 minutes, and 8 seconds, as well as 1 hour, 15 minutes, and 10 seconds. Two more, 1 hour, 16 minutes, and 42 seconds, and 1 hour, 17 minutes, and 18 seconds. And as far as the link regarding the meeting on September 19th of 2018, if it's possible for me to withdraw that, I don't feel that it really is necessary or adds anything.
So you're not giving a 1 or 2 sentence statement of what it is that's on there that
So,
you want us to see.
well, as mentioned previously, for the meeting on 4/12, 4/2/16, that is a select board meeting relating to the appointment of a DRB member, and the same for the one on November 28th of 17. And the material that I'm encouraging this board to take note of are comments made by the chair of the select board pointing out the importance of people who serve on the DRB not advancing their own opinions, but rather applying the language that's in the bylaw. Concerning the meeting on August 15th of 18, I would draw your attention to the comments of Mr. Paza, where he's on tape as saying words to the effect that my thoughts are, I'm going to look for every loophole I can to not force a landowner to do it. And then at 1 hour, 15 minutes, and 10 seconds, similar comments to the effect that verbal language that's written down here isn't tied to here's where the path is going, I can't work with. We want to see maps. In the context of the meeting where that comment was made, it's making it clear that there is the belief on the part of at least one member of the DRB that the language of the bylaws is malleable. At 1 hour and 16 minutes and 42 seconds, another member of the DRB draws attention to the fact that there is in fact an ordinance in place, and to not apply it consistently or equally is problematic. And then at 1 hour and 17 minutes and 18 seconds, further comments by Mr. Paza about his feelings that it's not right to make landowners be required to do certain things that may, if you watch the video, you may interpret it as him saying that they shouldn't have to do them even if the bylaw requires.
Okay, any other testimony? Would you like to cross-examine Mr. Pierce?
I thought we were talking about Shelburne Green. Is that the case?
You can
Um,
cross-examine him, or
I'd like to
what
address
is your,
I thought we're talking about Shelburne Green. Are you questioning my ability to serve on the DRB?
The complaint is concerning the principle that I mentioned at the outset, which is prejudgment. It's not about, in my view, I'm not talking about Shelburne Green per se.
Oh, okay, so I have a question. Again, are you talking about Shelburne Green complaint, or are you talking about my ability to be on the DRB? It's not clear, because you're citing other different applications which all had their specifics on the discussion. I think that clarification needs to come to the Ethics Committee.
so if I understand it, we have a complaint here, alleging that you violated the ordinance by not disclosing that you had made a prejudgment of a decision. And one way of, I think, I don't want to put words into the mouth of Mr. Pierce, but I think what I'm hearing is that making your failure to disclose the prejudgment is problematic in this particular case. And that what I'm hearing is that he's presenting the general view of the select board chair, at least in this in that video, that making statements that the statement you made expressed an opinion of your view of Shelburne Green. So therefore, I'm gonna say it's relevant, but I'll let Mr. Pierce make his arguments, and you can cross-examine him.
Who's first?
You can cross-examine him, and then.
Are all those sightings that you're quoting and reference me, are they related to the Shelburne Green application? Or are they related to other applications?
They're related to the concept of prejudgment.
That was not the question. The question was, are they related to Shelburne Green applications, which is why we are here, or are they related to other applications?
I'm here because of my concern about prejudgment. The complaint specified a specific instance of prejudgment, but the tapes that I am referring to that came most recently are in connection with the issue of prejudgment.
Okay, Mr. Chair, this goes back to one of my opening questions. As the DRB is in session and we are talking about different applications, opinions will be formed amongst DRB members and opinions will be voiced to the public. And if that can be construed as prejudgment, then we as a DRB need to understand how we operate. And I'm fearful that it might be that we just have to be quiet and not let the public know any of our thoughts.
And we speak through our decisions, so I can't tell you
Understand.
how we're going to decide this and
I
whether,
understand.
how that relates to your question.
Okay, so there's no question, I have an opinion on Shelburne Green, on the change in hours of operation of the cafe, and I substantiated my opinion on why I believe it met the Stowe Highlands criteria, because there's no way that existing business conditions can be foreseen at the time an application was submitted. Just normal business in the commercial business world, you have to adapt to market conditions or you're subject to failure. It's hard enough out there. So I was basing my opinion on my experience in industry that, yes, you have to be adaptable to market conditions. And the Shelburne Green change in cafe operating hours met that criteria. So I substantiate that on the public record. You can see that.
Well, the question before us, that the complaint states that you had that opinion, you voiced that opinion in 2016. In 2018, another hearing on Shelburne Green came up, and that you did not at that time disclose that you had made that statement 2 years prior, nor did you say, even though I made that statement, I think that I could be fair in deciding this matter. That's the allegation. I don't know if I haven't heard anything saying that that allegation is not true, but if it's not true, this is your opportunity to say that.
So clearly, the 2018 Shelburne Green application, I don't remember all the things I said over 2 years ago on the subsequent application. Had I known and understand the ethics ordinance that this would be a potential violation, I would have clearly stated, here's what I said before, but I still feel I can have an open mind about, this application. So again, it goes back
Right.
to
And so
awareness
you
of
can
that.
make that argument to us, and we could
Sure.
decide whether to take that in consideration when we make our decision.
Absolutely.
So okay, we're at questions from committee members so you're done cross-examining? Question from committee members of Mr. Pierce
Just Mr. Pierce?
at this point.
I have questions.
Mr. Pierce,
Yes.
go ahead.
Mr. Pierce, did you intend the additional videos that you sent to demonstrate a pattern of prejudging or a pattern? I wasn't quite sure if you thought that this was a pattern of somebody who had an agenda that they were pursuing on their own, or that they had repeatedly made prejudgments, or was this evidence meant to bolster your claim that the Shelburne Greens exhibited a pattern of prejudgment?
I'm not an attorney, so I don't know all of the intricacies of it, but I would say that it's more the former than the latter.
Okay. And the select board footage was meant just to reiterate the role of separating functions between planning commission and DRB.
Well, perhaps to put it differently, the importance of DRB members who are quasi-judicial officials, limiting their role to applying regulations and not doing more than that.
Okay, thank you. Thank you, Mr. Chair.
Ms. Webster?
Yeah, I guess my concern is that the complaint, and I understand about prejudgment, and that's a major concern in anything that's a quasi-judicial hearing. But my main concern is that the complaint specifies that it's related to Shelburne Green. And so my concern is the other corroborating evidence, or I guess my concern is that it can't be just based on prejudgment, although I think that that could be problematic in any quasi-judicial forum. But that I don't know if we shouldn't just keep it germane to the complaint in hand.
Well, we could discuss this in deliberative session, but for now,
Right,
any
right.
questions of Mr. Pierce? Mr. Deming,
No, no questions.
Mr. Little?
No.
My question, based on your comment and the video that you turned to, is I've never served on a DRB. Is a DRB a quasi-judicial body?
Yes.
And I think I've read the rules of the DRB, and seems to be they relate to quasi-judicial hearings.
It is, we do.
Okay,
On the record review.
okay. Does the DRB have any duties in addition to serving on a quasi-judicial role to hear applications?
I want to say no. That is their principal occupation, is to review applications that come to them either as original jurisdiction in the case of conditional use application, or they will hear appeals. But they're a body that, when they were created by the select board, were known that it was known that they would be a quasi-judicial body. Furthermore, that it would follow the Municipal Administrative Procedures Act, which has its own set of fair play requirements.
And does the DRB have any role in influencing the town plan or zoning regs?
My belief is that a quasi-judicial body such as the Development Review Board must be very careful whenever it wades into policy issues. And for the same reason that judges need to avoid doing the same. They don't have a formal role. I'm sure that there are many members of the DRB and former members who feel that it's valuable and important for the members to influence policy, but it's something that I have always cautioned DRB members to avoid. If they become invested in policy, I think that runs the risk of creating conflicts when those policies come into play.
Mr. Chairman?
Yeah.
There is a secondary role, much reduced role that the DRB does play, and it does not deal with policy, but it deals with clarity in the zoning rules and regulations. There are some instances where it is not clear, either by design, because the Planning Commission wants the DRB to have flexibility in its options, or things just aren't clear because they're not clear. And so what we try to do as a DRB is feed that back to the Planning Commission, saying, you've got to address this because it's not clear. We don't know how to rule on this because we don't understand it. An example would be the paths. We actually asked the Paths Committee to come in and provide some clarification on what you're looking for, and our response back was like, we need more. This is not enough information for us to act upon as a quasi-judicial board on what to do. And when there's ambiguity and confusion, yeah, we'll side on the landowner.
I understand that. So if,
So, again, I'm sorry, so I was feeding back. That is another role that the DRB does play. And again, not for policy, but for clarity.
thank you. Well, I may have some questions of you I'll get to later, but in the meantime, I think you have another question of Dean, then we'll turn to Mr. Paz.
Well, I was going to, because Mr. Pauza had raised a question, but I'll wait.
Okay.
So if I may respond to his response to my comment?
You'll have an opportunity. I don't think we've turned to you to present testimony, right, yet, or cross-examine, or be cross-examined. When we're done with that, you will have an opportunity to
But
ask him questions during your cross-examination or later.
I'd like to respond to his comment on my answer to your question. It's all stemming from your question.
Okay.
And that is, there's nothing in the DRB's charge that assigns to it the role that Mr. Pazza claims the board has.
Okay. And do you dispute that?
I haven't read the charter. It seems like common sense. If we're supposed to interpret the rules, we don't understand the rules, we have to go back to the rule maker and say, provide clarity, please.
Okay. But,
Mr. Chair, can I ask a question?
yes,
The video footage with, I think it was Kate Lally, that was not quasi-judicial. That was a consulting with the Bikes and Paths Committee, correct?
That was a meeting that was, that discussion took place outside of the context of a hearing. So it was, I think, in essence, there was a request made by the Development Review Board, the request was made by the Development Review Board to the Paths Committee, and the Paths Committee responded by sending someone.
But that was during a DRB meeting?
It was during a meeting,
Okay.
and it was precipitated by an issue that came up, that arose during a hearing.
Okay. Thank you.
would you like to present any testimony or make any comments at this time?
Yeah, comments. So I want to make sure that the committee understands why I said what I said with regards to the Shelburne Green application. So I don't dispute that I said it, but I did substantiate it. And I do believe I had, ample background on why I substantiated it. Change in marking conditions, not foreseen at the time the application was originally submitted, in my mind, supports if they wanted to go forward with a change in operation hours. So it wasn't just a casual comment, unsubstantiated. And again, it was in a DRB meeting. We were in session. We were live. And that is, that's banter that we have back and forth as DRB members trying to understand things. So I provided that comment to the applicant. Don't dispute that at all. Okay. And again, if I knew that I was, or suspected I was violating an ethics ordinance, I would have made that clarification at future meetings, but I was unaware of that.
Okay.
If Mr. Pierce knew that, it would have been nice to have known, so I could have clarified it.
Okay. Do you want to cross-examine?
I wasn't aware of the comments made at those earlier hearings until after the fact.
Okay.
I was not present, in other words.
Are there any questions from Mr. Plaza?
Do you think that the statement that you made in April of 2016, or notwithstanding that statement, were you able to continue to deliberate on that application and the future versions of it based on the evidence and, I guess, overall in a fair manner?
You're talking about the statement I made with regards to the hours of operation?
Yes.
With regards to hours of operation, I made myself clear on that, and I still stand behind that. Other items with that, I'm completely open-minded, making decisions on evidence and going against, what the town rules are. And again, I think my opinion that I offered was substantiated. It wasn't a casual opinion just saying, oh, because. So
I want to explore that a little bit, explore what happened in April of 2016 just a little bit more.
Sure.
And I understand what you might call the pre-deliberative session deliberations, when
Yeah, right.
there may not be a clear line all the time for a quasi-judicial body between taking testimony, questions and answers, and dialogue between and among board members before the evidence is closed.
Correct.
And after it's closed, when you either are deliberating in public or deliberating in private. So, and my understanding is that the applicant in that case had said they didn't think there was enough stuff in favor of overcoming the Stowe Club Highlands hurdle
Correct. They did.
to warrant presenting on that. And that's a complicated, Stowe Club Highlands is a somewhat complex legal standard. And so at that point, were you articulating that, well, take me from there through what you said and why you
Okay.
said it.
So here's an applicant coming in with an application for some infrastructure upgrades that they're talking about, and then, well, we were considering do a changing of operation to the cafe hours, but we know you guys want to approve it. Kind of what they said. And it's like, well, you're thinking I want to approve it. Hang on, I would approve it because I think there's no way you could have known the business conditions when the time of the permit was submitted, and I would support a change in operating hours. So I kind of let them know what my thoughts are. I did that, no question about it. And so the applicant took that, and okay, so how is that different than banter we might have as DRB members when we're going through an application? What do you think of this road thickness, or this road width, or that road width? Again, kind of the same thing. We're disclosing our opinions of what we think of different facts. And that's how I viewed what I did.
What did the applicant ultimately
They
choose to do at that hearing?
At that hearing,
on Stowe Club?
They chose not to go forward for a change in operating hours. So it did not change their application.
Okay. Okay. Thank you.
So now,
I'm trying to understand. You have opinions of how you view facts. I don't quite
well, here-
understand what that means.
This is, to me, this was common sense. In the business world, market conditions change. And they were coming in, they didn't even want to put in a change of hours because they thought it would be rejected all completely. And my experience in the business world is that if you don't adapt to new market conditions, you're handicapping yourself, and you're not serving your interests as a business. So I want to let them know that, okay, based upon this thought process, I would support that. So granted, they didn't provide me statistical data, backing up anything they were saying. It was, again, common business sense. You have to adjust to market conditions. A permit that was previously issued, this is a piece that I felt could not be projected, how it would be changing.
And what do the regs say about market conditions being a factor in making your decision?
I'd have to, okay, I'm going off of memory, off of the Stowe Highlands ruling, but if it was an unforeseen change of conditions that couldn't have been predicted, that qualified for a change in the permitting conditions.
In general, do the regs talk about market conditions
The
in
regs
making your
don't.
decisions?
It's the Stowe Highlands decision. And I'm not a lawyer. I'm just a common town citizen. But my understanding is the DRB, we just can't waive things. We can't change things arbitrarily. There has to be a background for why we would change a previous condition. And so what we often do is we use the Stowe Highlands criteria, which there's three different sets of criteria that apply Don't ask me to quote it right now because I don't remember all three of them, but one of them was unforeseen change in business events or conditions. And I felt that applied. And again, we don't arbitrarily change previous DRB rulings or permitted rulings.
Any other questions?
Mr. Pauza, do you, but you're not disputing that the reason the applicants withdrew their application is because they believed it failed the Stowe Highlands test?
They didn't withdraw the application. Again, they submitted the application, had some infrastructure improvements that they wanted permitted. Then they were considering a change in operating hours. And at the end, they decided not to go forward with the change in operating hours, just the infrastructure improvements, which they submitted and we acted upon.
But in Dean's complaint, he says, this is in reference to the March 2nd hearing. At the hearing, the applicant's own representative indicated, among other things, I'm taking this as a quote, "The applicant is withdrawing the request to extend the hours of operation of the cafe at this time due to the inability to meet the requirements in the Stowe Club Highlands test." So that seems to me to indicate that the applicant themselves believe they failed the test.
The applicant themselves believe they would not
But-
meet the criteria. That's correct.
But your view is they didn't fail the test.
That is my view, yes.
So you felt that you were in a position to judge that better than they were.
It's my job to judge. That's what I do as DRB.
And you don't see that as a pre-judgment of the merits?
Our job in DRB is to look at the town bylaws as well as see how they intersect with any state rules and determine how we should rule on a particular application. That is what we do. And many times, sometimes, let me back up. That is my position, and I'm staying behind it. I don't know what the applicant knew. I don't know what the reason was. They might have felt that they didn't want to risk their infrastructure improvement, but I'm speculating right now. It's dangerous. So they had something definitely that they wanted to have approved, and maybe they didn't want to have that jeopardized.
I mean, if I could just follow up. Let me just ask, did you have any conversations with the applicant after this, outside of the DRB?
Oh, absolutely not.
Okay.
No,
And none prior?
none prior. Absolutely not.
Thank you.
Go on.
I don't know how to put this and not have it sound right. Do you feel that as the DRB, it is your charge to try and interpret the rules, or do you look at them in the straightforward way in which they're written? I realize that sometimes when new bylaws come along, you can drive a Mack truck through them.
Yeah.
And because the planning commission doesn't always see, because they're not applying them. But do you
Sure.
apply them as written, or do you try to interpret them and bend them?
Great question. First thing we do is we apply them as written. Sometimes we don't agree with them, but that doesn't matter. That's not our job, whether or not we like the rule or not. We have to say, what is the rule and what is the application? How do we rule? And there's some cases that are very cut and dry, and it's very easy to understand how we apply the rule. There's other cases where they get a little murky. So now we try to understand, what is the intent? What is the town plan trying to do? How have we looked at this on other ones? And then we rule based on that. And we'll have debate amongst ourselves. With the more complicated ones, it'll be a private deliberative session. Then there's other ones that are just like, the town rule is so not clear. And when they're not clear like that, we go in favor of the landowner.
Okay.
I'm trying to understand one thing, and I'm not sure this is particularly, I'm not sure it's relevant, so, but I'll ask anyway. So you said sometimes the regs are not clear, so we have to let the planning commission know that.
We try to keep tally of things that are not clear to us, and we try to feed that back to the planning commission. Can you tighten this up? And sometimes the planning commission comes back and says, no, we want them like that, so it gives you guys a little bit of freedom. Okay.
Right. And that makes sense to me. That's definitely a role of a quasi judicial body.
Right.
That we have trouble making decisions because the regs aren't clear. In one of the videos provided to us in this hearing, the discussion with the planning commission, and I think it had to do with sidewalks or something on Spear Street or Bishop Road or whatever. I know it's not related to Shelburne Green, so that's why I'm a little hesitant. But I'm just trying to understand. Maybe it impacts how you viewed the Shelburne Green.
Sidewalk. Shelburne Green.
Paths or sidewalks, paths
they're,
or,
they're different. They're different things.
I know it's different. But what I heard was sort of advice to the planning commission on the advantages and disadvantages of requiring sidewalks in the
So-
regs. And if I'll stop there if I'm totally wrong on that. So, but in hearing that, my question to you, is that the role of you as a quasi-judicial body on what the regs should be as opposed to they're not clear?
I don't want to offer opinion on what the regs should be. I only offer opinion when the regs are not clear.
Okay.
Now, there was a case where, okay, for example, when the path, Kate Lowry was in talking about paths. That was not we were just in committee. It was not a quasi-judicial session. And we said, boy, it would be really good if we had a map that showed where you want paths, because then that would make it very clear for us to rule. But since we don't have that, we would rule amongst ourselves how we should do it, because it's something that's not clear.
So your position is we speak to the planning commission only when the regs are not clear
We try to feed back to them, correct?
on
do.
clarity, not on what the policy should be.
Oh, no, just clarity.
Okay,
We don't
thank you.
understand this rule. Can you help clarify it for us, please?
Okay. That's helpful, thank you. Any other questions? Okay, final comments. Bill, did I cut you off? No. Okay, final comments from the complainant, then the respondent.
Keep it short and sweet. I'll wait for the train. The ethics ordinance bars prejudgment by members of quasi-judicial bodies, and you, as a body, need to decide if the evidence for you establishes whether or not prejudgment has occurred. This is not a question of a single application. It's really a question of a critical tenet of fair play, and it's central to the quasi-judicial process.
Final comments?
Yeah, so going back to the 2016 application by Shelburne Green, I had no predisposition on the hours of operation. I wasn't thinking ahead of time, oh, they should extend their hours. The applicant came in, he presented his application, he had comments on hours of operation. I provided my opinion, my feedback, and I substantiated and justified it why we were in session. It was not anything I came into the committee predisposed with. Now, had I known that would have prejudged me for future applications for that particular Shelburne Green, I would have clearly issued a statement anytime Shelburne Green came in, so they knew that. Yeah, so
And
that's,
that never came to a vote,
which one?
the hours. They dropped it, so.
At that time, they absolutely dropped it, and it didn't,
So it never-
was not part of it, correct. It did not.
But it did come to a vote
Future ones,
well, a month or two ago,
that's correct, approximately,
September or whatever.
yeah, over a year and a half later.
Okay.
Mm-hmm.
Anything else, Bill? Pete? Tom? No. Mike? Gwen? No? Okay, I close the hearing. We will go into deliberative session, and now, no, close deliberative session. And now that the hearing's over, as long as it doesn't impact our decision-making, people can speak whatever they want, as long as it doesn't impact our decision-making. Ms. Keough.
I don't know if this will impact your decision or not, but sitting here, if I understand correctly, Mr. Pauza has recused himself from all future Shelburne Green proceedings. I also understand that the complaint asks for that relief and some education. If that's the case, and my understanding could be wrong, I don't understand why this hearing is going forward, because there's no judiciable controversy. The matter is moot. It would be moot under Houston versus
Okay.
Town of Waitsfield and other matters. And
Well,
therefore,
this impacts our decision, so I'm going to have to cut you off.
well, I would like to speak as a public citizen and a former member of the DRB and a taxpayer of the town of Shelburne. I feel that this proceeding should not be going forward because there's nothing for this public body to decide. The relief has been granted, and therefore there's no decision to be made.
Well, as we said earlier, this came up earlier, you may not have been here. Ms. Keough? This came up earlier, you may not have been here. The ordinance authorizes us to take additional, make additional sanctions, and that's what we'll consider during our deliberations.
Those sanctions haven't been requested by the movement, as I understand it.
And we determined earlier that the complainant does not have to request them. That's the Ethics Committee discretion. Okay, I'm concerned because this is impacting information that we're going to use to deliberate that didn't come out during the hearing. Okay.
Can you have public comment?
No.
Just one.
It's a quasi judicial hearing. We don't take public comments in quasi judicial hearings. Look in our rules.
My name is David Hillman. I am on the DRB. And I just wanted to read one statement out of Shelburne Development Review Board Rules of Procedures and Conflict of Interest Policy. And it states, when it talks about prejudgment of merits, this shall not apply to a member's particular political views or general opinion on a given issue. I think Jeff did nothing more than offer his opinion. So I don't understand why we're here.
In the future, these are, Mr. Pauza could have called Ms. Keough and Mr. Hillman as witnesses, and then it would be part of the record and part of the testimony. And I tried to make that clear earlier. I guess I hadn't.
I missed that part about extending to witnesses in the audience.
Yeah,
Had
well,
I heard that, I would have turned around and I would have asked, does anyone want to speak on my behalf?
Move to reopen the hearing.
is anyone okay with that?
I just want to point out for Ms. Keough's benefit that one of the actions requested was that he requests that the committee determine that the public official violated the ethics and conflict of interest ordinance, and he said he doesn't think he did, so that's why,
I said, I don't know.
Right.
yeah, wow.
Okay, so, right, we don't have an admission of a violation. We cannot find a violation because we don't have an admission or a stipulation. Thank you, Gwen. Okay, I will reopen the hearing for, how many witnesses do you want to call?
How many people would like to say something on my behalf? 1, 2, 3, 4, 5.
Well,
Five.
related to the violation.
Related to the violation?
Okay. Okay,
Okay, yes. Okay.
I will, you think we can do this in 10 minutes we'll see how it goes.
We'll see how it goes.
Okay, call witnesses.
Thank you.
Right. So when the witness comes up, I will administer the oath.
You want to do it in mass?
Uh,
We do it at DRB all the time. It goes
okay,
much faster.
Well, just identify, so I know who's taken the oath. Identify your witnesses now.
Oh, please stand up. Please rise. For the oath. Sir?
Okay? 1, 2, 3, 4. Okay, so, and can you give your name so we can have a record of who took the oath?
Mary Kehoe.
David Hellman.
Norman Stanislaus.
Mark Samet. Bill Posey.
Okay, we have that? Okay, now I've got to find the oath. I think it's,
Oh, wait, you
swear or affirm that you will tell the truth
The whole truth and nothing but
and
the
nothing
truth.
but the truth.
Under pains and penalties of perjury.
You got it.
I do.
Call Mr. Hill.
Okay, so David Hellman,
We
just for
will
the
allow
record.
you to call witnesses after this. I did not make it clear under our rules that Mr. Pauza could have called witnesses during his testimony. And so I decided, it's a matter of fairness, I'm letting him do that.
I understand that, but I would express the concern that the comments, the testimony that is offered may stray from the central issues that are before.
And I'll have to rule on whether it's relevant, and I will take that into consideration.
Okay. Again, David Hellman, and I am on the DRB board, and I just will state what I previously had said so that it's on the record, that according to the Shelburne Development Review Board Rules of Procedure and Conflict of Interest Policy, it states when it talks about prejudgment of merits, it continues saying, this shall not apply to a member's particular political views or general opinion on a given issue. And in my opinion, what Jeff did was offer his opinion. And as a DRB board member, as he stated in his testimony, we're constantly, as we go through testimony and hearings, and a lot of the work is opinion, trying to understand how the applicant is conforming to the rules and regulations. And I believe it was just nothing more than opinion. And then secondly, I just wanted to state that in the ethics conflict zoning ordinance, I believe there's other options, avenues that could have been taken with this. Certainly you can come to the ethics board, but my read of this is Jeff could have been directly approached.
Objection, Mr. Chairman? Is this?
You can object.
I'm objecting to the citation of sections of the ethics ordinance that have to do with optional processes for filing a complaint. I don't see how they're material to what it is you're deciding.
What's your point?
Well, my point is, I guess I'm troubled that it's here because to me, it's not really what I consider, I just like to see us, we're a small town, and it's not good, cordial behavior, in my opinion, to go directly to the ethics board when we have options of discussions directly with the applicant. It also talks about the ability to go to the chair of the select board and go
I
through them.
object,
There's
Mr.
other
Chairman.
avenues.
I think it's relevant, not the ethics committee may or may not consider it a factor in making our decision.
Okay. Next.
I have one question for the witness, and that is, was the complaint filed under the ethics ordinance or the DRB's rules of procedure?
I don't know. It was filed, I don't know. Ethics ordinance. And that's in the ethics
It was
ordinance.
filed
Those are
pursuant to the
avenues.
ethics ordinance,
But not the DRB's rules of procedure.
not that I know of.
Okay,
Not what you have in front of us.
right. But I'm just saying that the DRB's rules and regulation given to us, that I look to as, that's what I abide by, that talks about opinion. That was given to us.
Okay. Do you want any more cross-examination of Mr. Hillman? Okay.
Hi, my name's Bill Posey. I've been before the committees in this town probably more than anybody. I've been around for years and I've been before everything. Opinions are offered by the planning commissioner, planner for the town on things when they're discussing it. They'll say, no, you're looking at that wrong, or something like that. Falls under the same category. All of them discuss things back and forth, may it be small or big, but that's, otherwise, why bother with the committees? Let Dean make all the decisions.
Hello, Mark Samet. I'm currently the vice chair of the DRB. I just think that the sightings to things that are outside of the Shelburne Green hearing and kind of could be taken out of context. And I didn't think this was about proving prejudgment. I thought it was based on my readings of the complaint, the way it's drafted, it's strictly aimed towards the Shelburne Green hearing or hearings. So, thank you.
Thank you.
Good evening. My name is Norman Stanislaus. I'm the property manager at Shelburne Green, and I'm also the site contractor. I sit here this evening before you, and I wonder why we are here. And I would ask the board to give me a little bit of latitude here with moving forward with a few things that I'm going to say. First of all, Mr. Pierce has came across substantial evidence, he claims, against Mr. Pazza.
We are, just to be clear, anyone can file a complaint. It's our decision whether that complaint has any merit. But I'm to protect the parties in this case. I think if the question is in any way attacking anyone for filing a complaint that they're authorized to do over the ordinance, I'm going to stop you.
Okay. That is where I was going with this. Okay.
Then I'm gonna stop
Okay,
you.
so I guess my only, I'm very concerned because this is a
Stop
gentleman.
you. Now, tell me you're going to change the subject, and you can keep talking.
Okay, so first of all, I do not know Mr. Pazza aside from his position on the DRB board. Okay, I have been before the board several times. He has always conducted himself in a very professional manner. Okay, that's number one. Number two, the select board or the townspeople at one point or another, they came up with a number of members that they felt would act in the best interest of the town on the DRB board. And I find it very, such a huge injustice that this gentleman would have to recuse himself, not only from future proceedings for Shelburne Green, but also an injustice to the rest of his board that he works with on an ongoing basis, and a great injustice to the town of Shelburne. So clearly, I just hope that the board takes into consideration that the extent of the comment, I have no idea who in fact it has harmed. And as I said, I have no personal relationship with Mr. Pazza, nor do I know him aside from being a board member. And there's one, and I guess that's it. I did have one further comment, but we will leave it at that.
Thank you.
Thank you very much.
Are there any other witnesses?
My name is Lee Crone. I'm the town manager, and I stand before you with a fair bit of trepidation because I did not initially intend to even attend, let alone speak. It seems that you are going to limit strictly the comments to, as you have suggested. So I will simply say there's a lot more behind this than meets the eye. You need to hear it, but I don't think you're going to allow it. Be glad to elaborate if you're willing to grant some latitude.
I can't say that what you're about to say is relevant without knowing what you're about to say. So, certainly any witness can start talking and I could stop the person.
Okay. I'll give it a try. You're in charge. As I understand it, this complaint relates to issues that began 3 years ago. If the issue were truly relevant 3 years ago, then why is it just coming forward now? There have been statements made by the complainant that we should neither favor nor disfavor anyone, and that's the job of a DRB. And yet, the complainant has had an extreme disfavor toward this project, this landowner, this case.
Well,
And it happens that there's some current cases that now, handily, we've taken one member out of that equation who can't hear those cases.
I hear you. Thank you.
I'll leave it at that.
Okay, any more witnesses?
Yes, me again. Hi, Mary Kehoe. Having had the pleasure to serve with Jeff Pauza on the DRB for a long time, I can tell you that there's no member who's more dedicated to following the rules than Mr. Pauza. You may not know this, but he wrote the rules down on the back of his name card so they would be there for him every time he voluntarily showed up on a Wednesday to listen to these very difficult, and I'll admit it, sometimes extremely boring hearings. And this gentleman has worked hard to understand the rules and to abide by them, and at every turn. I never saw him prejudge any matter whatsoever, and in fact, I saw him change his mind time after time as evidence came in, as evidence of his flexibility and his dedication to the rules of the board and the ethics that govern those rules. I agree with Mr. Crone that there's a lot more going on here in this matter that has to do not with this member, but it has to do with the applicant. I recused myself from matters having to do with the applicant because at the time my son worked in the law firm for the applicant, so I didn't feel I could serve. So I removed myself and sat in the kitchen, and I could hear Mr. Pierce aggressively examining the applicant. So there's more going on than meets the eye here. Nevertheless, I believe that this matter is moot by virtue of the fact that Mr. Pauza has fallen on his sword. I would submit unnecessarily for the benefit of the good of the town to make this a smaller matter than it ought to be. And I urge the board to render this matter moot because there is no longer a need to make a finding about what Mr. Pauza may or may not have done wrong because he's recused himself, so there is no longer any harm that can befall the town. Thank you.
Anyone else?
There's another larger issue here that I'd like you to please be aware of. We ask volunteer members to sit, listen to facts and evidence, and render decisions. And as has been stated over and over, any of you who've ever sat on a board know life isn't crystal clear. So opinions necessarily enter into it. In fact, the courts have ruled over and over in land use cases that where bylaws are vague or ambiguous, deference must go to the landowner. So that's not just the DRB flexing arbitrarily. But if we end up muzzling board members by telling them they are not allowed to issue opinions in the matters before them, are we telling our board members that they can say nothing in the context of a hearing and have to sit mute and just close a hearing and then the applicant has no idea what's going on. So I think there's a much larger issue here in how our boards can function and how our board members can function. And if you find that this is a violation, you're basically telling all of our board members they might as well not even speak in the context of a hearing. It'd be one thing if statements were being made at the farmer's market in the context of a hearing before a board and somebody's out chatting about it at the bar or at the farmer's market. Clearly, we know that's impermissible speech or behavior. This was in the context of a hearing. If board members can't say what they think or what they feel, why are they there?
Mr. Pierce, do you want to cross-examine any of the witnesses or make any comments?
Perhaps the latter. I think folks who've testified and suggested that there's a personal motive may themselves have a dog in the fight, so to speak. They have an interest that they're pursuing, and that an approval from the Development Review Board would advance their interests. So they have an interest in making the comments that they're making. I think the suggestion that I aggressively questioned an applicant at a time when Mary Kehoe had recused herself neglects to recognize the fact that I was at that hearing as a representative of the town manager who had seen fit to enter an appearance in the matter and to have a position argued before the board. And furthermore, the things that were presented and argued before the board were reviewed by the then manager before the hearing. So I think that there are two sides to every story, and this is, insofar as we're focusing on people who have a stake in the outcome related to Shelburne Green, the record for that application goes back several years, and it suggests, or does more than suggests, it indicates that there have been technical issues related to conformance that go back years and that were sufficient and sufficiently clear to the top executive official, the former town manager, to support the position of the Planning and Zoning Office. Now, Mr. Crone, shortly after taking office or taking his position, was informed of these issues, and I don't recall him indicating the kinds of concerns that he's indicating now. So I think that, again, there are two sides to every story. I do find that it's unfortunate that the hearing trended this way after it seemed like it was declared closed. I don't know that any of the folks who spoke would have suffered any kind of disadvantage had they not been allowed to provide testimony. I would suggest that the board needn't give it much weight because I didn't hear things that were relevant or are relevant to this complaint. I will leave it at that.
Okay. Okay. Any final comments?
No, I think you understand my position.
Okay.
I have a question.
Yes?
When they go before the DRB, this this piece of property, you were involved in the brewery question? I mean, specifically the. No, weren't you? Is that?
I was involved with one of the applications involving Shelburne Green. Yes, that is correct.
And that particular one was the brewery.
This particular one was dealing with an infrastructure improvement and a change of an infrastructure improvement for the brewery. That is correct.
So that all applications all go under the banner of the green?
The ones that we're referring to are Shelburne Green. That is correct. So when we say Shelburne Green, I think what we're referring to is the brewery that is part of the Shelburne Green property. There's other entities there also.
And how are the other entities go before the DRB? Under Shelburne Green, or?
I would assume they go under Shelburne Green when they come in. That is correct. We view the Shelburne Green as a property, as an entity, as a commercial kind of development. So the brewery is one entity on Shelburne Green. There are also several others.
But the brewery is the one that this is all about.
The brewery is the one related to this.
Okay, thank
Yes.
you.
Any other questions from committee? Well,
To the
yeah.
best of my understanding. Okay.
Okay. Before I close the hearing, I just want to make one comment, that I note that both Mr. Pauza and Mr. Pierce requested that this committee do help with education. I can't remember the exact words, for the DRB, and guidance, provide guidance for the DRB. And I don't know how we are going to decide this matter, but based on comments I've heard tonight, I'm glad that both of you requested that. Whether that guidance to the DRB comes from this committee or from elsewhere, I think it would be helpful, because what I'm hearing is just as you're not clear on exactly what you can say when, and when you can voice opinions, and the role of the DRB, and the role of the Planning Commission, and the role of the Select Board. I think that that's something the town would benefit if all of that were made clear. And I don't know exactly how that can happen, but I will be. I think the Ethics Committee can do its part to educate the DRB and every committee in town and board on the requirements of the Ethics Committee, and we will do that no matter what happens with this case. And I hope that there's another vehicle to establish clear direction to every CBC and the DRB in particular, because that's who's here before us, on their role and what they can do in open hearing, what they can do in deliberative session, what they cannot do at all, would be very helpful. And I will work with the town manager to try to see how the town can provide that guidance.
Thank you.
I close the hearing. We will meet across the hall in deliberative session, and we'll see where, and we'll go from there. Thank you all.